think the others can come in, and if you're on the end of an aisle or end of a row and somebody wants a seat desperately, would you mind moving up just so that the latecomers can squeeze in? Well, good evening, everybody. My name's Lynn Haltane. I am the Executive Director, very proudly, of the Victoria Law Foundation. And tonight we gather on the land of the Wurundjeri people of the Kulin Nation. And on behalf of all of us, I thank them sincerely for their careful custody of this place for millennia through the efforts of their elders, past, present and rising. Well, in a week where we've had all the nation's mainstream media outlets running a concerted and unusually coordinated, you'd have to say, campaign against secrecy, and Four Corners focused on the Lawyer X story, here we are talking about suppression. So that was outstanding timing, entirely fortuitous, but good nevertheless. The legal system, as you are very well aware, is a pillar of our democratic structure, and the transparency or the opacity of it raises some really fundamental issues about how it works and in whose interests. And suppression orders, it seems to me, which block information about some matters in some circumstances, are a really clear example of that challenge. So they're a lightning rod for debate around how the justice system gets done and consequently our faith in it. So tonight we have gathered an outstanding panel, I'm sure you will agree, all of whom speak as very knowledgeable and highly experienced people rather than representatives of the organisations for whom they work. So let me introduce them to you. We will start with Matt Collins on the far end, Dr. Matthew Collins, AM QC, President of the Victorian Bar and renowned barrister, often working in media and in fact currently working for the ABC on a particularly interesting matter around secrecy which may or may not come up. Next to him, Vincent AO QC, the Honourable, the man who literally wrote the book on suppression, the most recent volume. It was called The Review of the Open Courts Act, and it too may come up this evening. Louise Milligan, investigative journalist with the ABC, who did write a book which was suppressed. Cardinal...
Not suppressed, withdrawn.
Sorry, my absolute apologies. The Rise and Fall of George Pell was off the shelves, withdrawn, for the period of the Pell trial, and I'm confident that story will certainly come up tonight. And we also have with us Rod Ratcliffe, who is the Principal Registrar with the Victims of Crime Assistance Tribunal and sometimes acts as the Jury's Commissioner as well. So he has two very useful perspectives on the issues that we'll discuss tonight. So let me just run through the format for this evening and a little bit of housekeeping. What I'd really like to do, because these events, this is our third Law and You Forum, are really around trying to explain the intricacies of the law as well as raising some of the key issues that arise. So clearly we pick issues that are of particular interest, and this one's a nice hot one this year. But there's some work to do, and I think making sure that we all understand exactly what it is we'll talk about. So we'll spend a little bit of time at the beginning doing that, because there are not only some confusions, I think, in the way people understand suppression, but there are some really fundamental and I think quite conceptual issues that arise. Like, does suppression stifle democracy by keeping the work of the courts under wraps? If we don't know what's going on in court, how can justice literally be seen to be done? If suppression orders are intended to reduce the risk of prejudice in trials, then what does that say about our attitudes to juries? That they can't be trusted to make sound decisions on the facts? And in this era of the very free flow of information around the world in seconds flat, is there actually any point in suppression anymore, when we can just go online and see the information courtesy of the Washington Post or the LA Times or whichever outlet you like, and, you know, the suppression is broken. So there will also be time for your questions at the end, and can I encourage you to use the Slido app if you're comfortable to do so. That means we can get through more questions more efficiently. The link, I think, is, yes, it's up on the screen, so you type that into your browser, and when you get to the Slido app, put in the event code, which is #LawAndYou, all one word, as you can see. And best to do that now so that you can bash out your questions as we proceed and get ready to send them. And please, whilst you're doing that, turn your phones to silent so that that we have an undisturbed conversation, which, by the way, is being live streamed. So good evening to everybody on the live stream, and is also being recorded for posterity and for you to share with your friends and family who missed it, sadly, and will be available tomorrow on our website at the Foundation. One more thing before we get underway. Please be aware that we are also very likely to mention some high-profile and some particularly egregious cases. So please be mindful of your own mental health in terms of the impact that might have on you if it's going to cause you any distress. Let's talk basics then. I really want to begin with what is a suppression order. Frank Vincent, can you tell us what a suppression order is?
Essentially, it is an order that prevents the distribution of information which is involved in some part of the court proceeding. It's an order that is made by a court prohibiting the dissemination of that information.
So, Matt, how does that work with contempt? Because I think in the public mind there is often a conflation.
Yeah, I thought that the title for tonight's session was really insightful. You know, are we distorting or supporting justice? Because that's what we're talking about. We're talking about the balance between protecting the integrity of the trial process on the one hand, a really important fundamental right, something dear to every lawyer and judge, and on the other hand, the public's right to know things which are necessary for our democracy to survive and flourish. Contempt is how we seek to reconcile those two competing interests.
So in terms of contempt, that comes after the fact, though, doesn't it?
Contempt comes after the breach. So a suppression order is made, the media breaches the suppression order, or is accused of breaching the suppression order, proceedings then follow against the media organisation, often the journalist individually, for a breach of the order. Colloquially, we call that contempt. It's a question of the breach of the suppression order. There is also a species of a common law offence known as contempt, which is engaging in conduct which has a tendency to interfere with the administration of justice.
Contempt is a much broader notion than suppression, and it can be directed to all kinds of things, like playing up in the courtroom or saying rude things about the judge, or a variety of behaviours which are seen to challenge the system generally, but and within that range of challenge you find suppression orders.
If you're going to criticise the judge, you should always do it under your breath.
or to say, with the greatest of respect, Your Honour.
Your Honour, yes. My lad. Louise, have you ever been subject to a blanket ban?
You mean by my journalism?
Yes.
Well, I guess in the case of my book, so for those who aren't aware, I did the first story about the complainants against Cardinal George Pell that said he had abused them when they were children for 7:30 on the ABC. And then I wrote a book which was much broader, and it was more about Pell through the lens of this terrible crisis that had infected the institution which he sat at the top of, the Catholic Church. But it also looked again at those crimes, and we now can say those victims, because he has been found guilty not just by a jury but also by the majority of the Court of Appeal of sexual offences. When my book came out, Victoria Police had been investigating for 2 years, and the day that it came out, the Director of Public Prosecutions made it public in the Herald Sun that the OPP had sent the Pell brief back to Victoria Police, and Victoria Police was free to charge if it wished. 6 weeks later, George Pell was charged with multiple offences. When George Pell was charged, my book had been on the market for 6 weeks. So in the Victorian jurisdiction in which he was to be tried, not other jurisdictions, we had always planned to withdraw it from sale if it was on sale by the time he was charged. I mean, there were a few wild claims that, we were somehow in cahoots with Victoria Police, and I have to say, as a journo, I wish I was, because I would have got it much quicker than I did. You know what I mean? Like, I wish that someone was giving me this information instead of having to traipse around, doing old-fashioned shoe leather journalism. But of course, I'm glad now that, that it was done the right way. But yes, it meant that my book suddenly became hot property, very popular at airports, for instance, and that, it couldn't be for sale in Victoria. And that was fine. That's what has to happen. I do feel, however, that, in this case, that the Cardinal was granted privileges which we haven't seen with other criminal defendants. Quite extraordinary. We still don't know the nature and quantum of the charges that he was originally charged with. We don't know the full number of defendants. It hasn't been made public by the court. It seemed to me, I felt, that there was unfairness in that. And I think the process has led me to believe that there is a real imbalance in the criminal justice system in favour of a well-resourced defendant. And George Pell is nothing if not well-resourced.
We will get to a number of the issues that you've just touched on in a few minutes. But Rod, from a victim's point of view, the purposes of a suppression order can be very valuable, very important in terms of protecting them at times. I mean, that's one of the purposes of suppression.
Oh, it certainly is. One of the things that I guess is obvious in some ways that victims aren't all the same. So whilst a suppression order can be very valuable, even victims who have become victims of similar crimes at similar levels can respond in different ways and can have different levels of trauma and recover in different ways from those acts of violence. So to suggest that the victim's perspective sits on this side of the wall and not that side of the wall is not giving credit to the individuality of responses to trauma through crime. So from my perspective, I think there is a need at times to quash some information in relation to a victim in order to protect them, to give them the best chance of recovering from that. But equally, there are times where the opposite is exactly true, where the openness of it is how they're dealing with the issue, and that's how they begin to recover from that. So it's traumatic either way, but I think the perspective of the victim, the individual victim for that case, or group of victims for that case, needs to be heard in some way.
Can I just say, as a journalist who's covered a lot of these types of cases, and I covered courts in New South Wales for quite a long time where there are nowhere near the suppression orders, as was made public this week in the papers, 490 this year in New South Wales and 1,200 in Victoria. I mean, they just come flying into the inbox, and they are not sought generally by victims. They're sought by people who've done something wrong and are embarrassed about it.
Well, let's talk about that, because that's one of the issues that's constantly thrown up, and I'd love you to go to that, Frank, because Victoria is now renowned apparently as the centre of suppression. Is that the case?
Yes, Victoria has a very high representation in suppression orders and has for a very long time. There seems to have been a culture of easier granting of orders in this state that I ascertained when I was conducting my inquiry. With respect to the situation of victims, I have recommended, and I think they've actually introduced the legislation, to enable victims to have their names and circumstances revealed. Quite a few of the victims were found that the process resulted in the effective concealment of the identity of the perpetrator. And they really hated that. And they were not ashamed to be the victim of a sexual assault.
They didn't do anything wrong.
There is no shame in that, and yet somehow or other we seem to continue to present it in that way. And these people said, I have been a victim, this person has offended against me, that ought to be open to public scrutiny and understanding.
There was one complainant in the George Pell matter who said to me, I don't want to be anonymous. I want to look him in the eye. I want to stand in that courtroom, because he wasn't given that opportunity, because they give their evidence off-site, which to me seems extraordinarily paternalistic unless they actually choose it,
Yeah.
And he said, I want to look him in the eye, because when I look him in the eye, he will know who I am and he will know what he did to me.
But the view of victims can vary very considerably. One of the saddest examples that I encountered of that was during my time as advisor to the Victorian Parliamentary Inquiry into institutional abuse of children. And we conducted a number of interviews, of course, as they did in the Commonwealth inquiry, and many of them were confidential, so people could come and tell us what they wanted to say. The particular case I'm referring to was of a very elderly woman. She was almost 80, and she wasn't well, and she had carried this secret for her from the time of her childhood. Her family didn't know about it. She didn't, even at that stage, she couldn't tell them about it, but she wanted to tell someone, and she wanted to tell someone in circumstances where her experience might be valuable to others. So you can get situations where people really don't want the world to know what's happened to them, and we ought to respect that. But on the other hand, there are many who would take what I regard as the proper view, and that is that they are victims, not perpetrators, and want the perpetrator clearly identified and what he has done or she has done made the subject of proper accountability.
When it comes to the why around suppression, I think, certainly the circumstance around victims is a fascinating one, and one that probably doesn't get the sort of attention it should, because we tend to lean on the cases that are around the risk to fair trial. That seems to be the majority of cases that certainly get public attention. So certainly the Pell case, the Adrian Bailey case, the gangland trials, and certainly the issues around Hinch's breach. So Matt, is that,
I think
in
that's
your
right.
experience, the majority?
I think that the reason is that, I think Louise's word is right, there's a paternalism that underlies the protection of victims, and that is enshrined in law. So in fact, it's not necessary to get a suppression order in order to prevent publication of the name of a victim or alleged victim of sexual assault or other forms of sexual abuse. That's just the presumptive position, very, very difficult to displace. Where the sharp edge is when the media wants to report on something, usually a salacious criminal trial, but it can be anything, and the defendant or the prosecution or both of them prefer that material not be published, because they argue that if it is published, it has a tendency to interfere with the ability of the defendant to get a fair trial.
So that's a really interesting point, because I think, Frank, I'd be interested in your view on this. Judges cop a lot for imposing suppression orders, but in fact the initiation comes from the defendants or the prosecutors, doesn't it?
It's often not opposed. There's often no contradictor at all.
It suits everybody to keep it under wraps. for a variety of reasons. And I think that's quite appalling. But the broader point that underlies a lot of this is that much of the law is paternalistic, and it involves an assumption that the ordinary citizen cannot be entrusted with certain classes of information because, in the famous words of Jack Nicholson, they can't handle the truth. The reality, from my perspective, is quite different. Much of our law represents the inherited prejudices of earlier generations, and it's been reflected in not only in suppression orders, but in all kinds of other areas. It wasn't that long ago when it was just accepted as axiomatic that you could not rely on the evidence of women and children. That was the law. And it is still lurking in the corners of the minds of many judges and in the way much of our administration operates. These notions have come from a time of an almost elitist approach to juries that I just do not believe was ever quite justified, and certainly do not accept as appropriate at this day and age.
Well, the point is, in other international jurisdictions, juries can make decisions unpoisoned by the hounds from the press. You know,
Like the US.
Yeah, exactly. And I mean, I think you know, it's a crazy example, but the O.J. Simpson case is an example where it couldn't have had more publicity, and you know, under the sort of arguments that have been made in this jurisdiction against, you know, juries and for judge-only trials and in favour of suppression orders, he surely should have been convicted, and he wasn't. Now, maybe they made the wrong decision and maybe the thing was a circus, but the point is the jury made their decision, which should be contrary to the idea that a person can't get a fair trial if there's a whole lot of, stuff in the public domain that would be prejudiced against him.
So, Matt, do you think it's showing a superiority on the part of the judiciary and the laws?
I think it's paternalism again, but I think there are two other important practical features at play. One is the media, which has historically been the safeguard of our right to know what happens in our courts, has gone through a seismic shift since the advent of the internet. You know, the loss of the rivers of gold from classified advertising, the loss of circulation of our daily newspapers, the increased sources, non-Australian sources of information available to all of us, means that the media does not have the resources it once upon a time had to go along and make the argument in a court that a suppression order ought not be granted, having regard to these sorts of high ideals of which we've been speaking. It's incredibly rare nowadays. I mean, it's been years since I got a paid brief to go to court and argue against a suppression order. The media simply doesn't have the resources to do it. And what that means, this is the allied second point, is that there is often nobody speaking against the grant of the suppression order. It suits, as Frank says, both the prosecution and the defence for the matter not to be played out in the newspapers, but it also quite often suits the judge for it not to be played out in the newspapers. Because if something goes wrong in a trial, for example, the jury gets discharged, the judge faces the risk of being criticised and reversed on appeal if the judge has not granted a suppression order, and as a result, it can be argued that the jury has in some way been tainted. So the path of least resistance for the judge, as well as the parties, is often just to grant the suppression order. The Court of Appeal is never going to criticise the trial as not having been conducted on a fair basis because a suppression order was granted.
So I really want to come to Rod on this in a minute, but Frank, one of the recommendations you made was around a public monitor, if you like, which would address that notion that there is very little opportunity to challenge suppression orders. The
broad structure I had in mind was that a judge who could make an order, that bit would be transmitted immediately to a central database which would be accessible by the media immediately.
So that would handle the flood problem?
That would put it with there. They would then have 5 days within which to object to that order. There would be a reserve power in the public interest monitor to challenge orders. The judge would have the ability to call upon the public interest monitor to ensure that the order that the judge was making was both necessary and appropriate. And if that were all done, it would simplify the process. It would enable complaints to be made where they needed to be made, rather than having to look at everything all the time or just pick up what was happening by accident. And in addition, it would also enable the public interest monitor to keep a record of the number of orders, the circumstances in which orders were being made and so forth, to maintain a kind of check about the operation of the system.
Do you think
Now, that's the bit that hasn't been done.
And without that mechanism, it's possible that the only contradictor would be a victim who isn't given a meaningful voice in every case. So I think if the media don't have the resources and it's too easy for those within the system, the judicial system, to acquiesce to that, then a meaningful voice has to be given to victims who stand outside of that realm and may be completely opposed to it, but aren't given that voice.
They don't have a seat at the table at all. I mean, I remember in the Pell case, in the committal proceeding, the QC representing the Cardinal made a joke and objected to the fact that the victims had requested a support dog and said, I thought they were for children and elderly people. And the magistrate Belinda Wallington snapped back, they're for vulnerable people, Mr. Richter. You know, so you know, they get a dog. They don't have a seat at the table. It's so outrageous. But I do think in the case of this as well, we have to remember it's not just about what happens in Victoria or what happens in Australia. We are operating in a 24/7 media environment with Facebook and Twitter and Instagram and Snapchat and all the rest of it. And I can say in this particular case, the international journalists, particularly those from America who have this fundamental constitutional belief in freedom of speech, they just don't support the idea of suppression orders. They don't understand them. They think they're tyranny. They think that, you know, they can't get their head around it at all. And they actually think that they're freedom fighters, you know, to break a suppression order like the one that we saw, you know, in the Pell case. I had long conversations with very eminent American journalists trying to explain to them that there's the guys in the second case, which never happened, which is a whole other story, but and they won't get their trial, and you understand as someone who's an empathetic person that that's not a good thing. So could you just hold off for them, you know? And in the end, you know, that was enough, but still, you know, they rage against it and they broke it. And then we have the situation where, you know, the chief judge of the county court is, you know, what's he going to do? Extradite the world? You know, it's just not going to happen. And so it just shows what a farce it is. And the Australian journalists, some of whom are in the room today, you know, assiduously stood by what the order, like we did what we had to do, and it was like we were being kind of punished for that, you know. What we couldn't report something that was happening on our own turf, but it was out there on the internet, and any crazy person on Twitter could say whatever they wanted because the court wasn't monitoring that. They were only monitoring what responsible court reporters and journalists in Australia were saying.
Judges have said to me that you will get the full story in time. You just won't get it now. That, justice will play out and then we'll tell you everything. Then you can have transcripts, you can have anything you like. But just not now. Is that sufficient? Matt, what do you think?
Well, I think that the Pell case, I should disclose I represent all of the media organisations, journalists and editors who have been charged with contempt arising out of the matter that Louise just averted to, so I will be very careful not to express any view about it whatsoever, other than to say these were the facts, that in that case, very shortly after the verdict was delivered in a court 300 metres from here, the outcome of that trial was shooting around the world. The newspapers all around the world were reporting it. The media in Australia was not. The media in Australia, after a couple of days, alluded, I think is the way to put it, to the fact that something very significant had happened in this city that could not be reported. And as a result, 34 journalists, editors and media organisations face potential prison terms and fines for allegedly breaching the suppression order and committing a contempt of court. Now, there are strong arguments on both sides. For the media's argument is that they were, as Louise says, careful not to name the cardinal, careful not to identify the charges of which he'd been convicted. The Director of Public Prosecutions would say, but by alluding to it, you invited people in Melbourne to go and find out the very thing that the court was being very careful to protect from dissemination in order to ensure the integrity of the forthcoming second trial. So these are very, very complicated questions.
They're complicated because they arise as a result of the original decision to make the order. And one of the rules that you tended to follow pretty closely as a judge was that you didn't make orders that really weren't sensibly enforceable. There were some circumstances, if you did, you might, or you could find yourself in a situation where you then had to react with force to enforce something that shouldn't have been done in the first place. And you look very silly, and you are very silly when you do that.
Rod, as you've said, victims vary in their responses, but certainly broken rights and victims advocacy groups have been quite supportive of circumstances like Louise describes around, please, 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 for example, in the Adrian Bailey case, don't go there because that will delay the trial, it will blow it up, and that's, does more harm than good for victims and their families in this instance.
And look, anything that delays ultimately a trial and justice in a particular case is going to run the potential of re-traumatising a person who's already traumatised. So if there is a more efficient way of doing it, if something runs the risk of delaying it, and whatever the culture is at the moment, it certainly does run the risk of delaying, even having mistrials. It's a very dangerous thing in the current environment to breach those orders and can very seriously delay. And it means for some victims that they have to perhaps give evidence again in court, so they go through the same traumatising process that they've already been through because of someone, perhaps well-meaning, but someone breaching an order that was there to protect that right of trial.
So Hinch, for example, was heavily criticised, by advocacy groups for blowing it up.
And in principle, you might even agree that what he's saying is very sensible, but it doesn't really help the victim in that situation because the victim is going through a process. They just want it to end. They don't want to be there.
I think it's when you have these super suppression order situations that it becomes really difficult.
Like the blanket ban.
Yeah, absolutely, and that happened in the Pell case without harking back to that. But I had some very particular personal experience because I was I had confidential sources in that in my book, and those people came from a community which has been profoundly betrayed by an institution, and I was not about to betray them. However, the Cardinal's defence were absolutely determined to get my notes and emails and text messages and so on from those sources. So I had to rely on what's called Section 126K of the Evidence Act, which is the journalist privilege, which is the right to protect your confidential sources. But it's a qualified privilege because it's subject to the discretion of the court. So I had to bring on a hearing to protect my sources. But because that was just before the first trial was to start, there was a suppression order in place. So that meant that I was going to protect my sources in court in secret. And the end point of that was if the judge had agreed with the defence's propositions, I wasn't going to give up my sources. A journalist never gives up her sources. And, you know, as I've said before, you might as well take your bat and ball and go home. It's all over. No one's ever going to trust you again. But also, it's important, and particularly when you're talking about people who don't trust anymore because they've been betrayed. So I could have been charged with contempt of court. Now, what happens then? Is that going to be in secret? Am I going to be prosecuted in secret? You know, it was terrifying and chilling that this was happening in Australia in 2019, and yet it did. Fortunately, the judge, Chief Judge Kidd of the County Court, took it very seriously, and we applied to the Victorian Attorney General under the Charter of Human Rights, and you know, Pell's lawyers at that point folded because I didn't get the impression that human rights was their thing. Law, that is. But you know, and so I remember thinking at the time, you know, it was like that moment, you know, with Dorothy in The Wizard of Oz where she throws the bucket of water on the Wicked Witch, and the Wicked Witch is gone. But it was months of extreme stress, and it was all happening behind closed doors. And why? Because there was this secrecy around the thing, but also because the trials had been split, again, I would argue unnecessarily.
I want to go back to the point that we were discussing earlier, because we're roaming all over the place, and,
yes,
and that's a fine thing. But Rod, we were talking about the extraneous noise around, you know, media involvement or interest, and, you know, fascination with particularly high-profile cases. With your jury's experience in mind, what do you think? Can juries separate commentary from fact? Can they be subject to appropriate directions and come to an appropriate conclusion?
In short, yes. I'd like to acknowledge the actual jury's commissioner who's in the front row in the middle now. Thank you, Mr. Dorr.
Front and centre.
Just nod
Evening
a lot as
Paul.
I speak, if you could. All of these ridiculous situations that we're talking about are predicated on the idea that people can't distinguish between fact and falsity. And we live in a society now where we're fed tens of thousands of pieces of information every day, and we are trained by that to process that information through a lens that allows us to question everything that we hear.
So you think we're better at it now than we used to be?
I think we're way better at than we ever were, because that's what we do, that's what human beings, that's what ordinary people do on a day-to-day basis. And the idea that we are not to know something because it may affect our ability, or it may prejudice us in the way we respond to a particular defendant, may in fact be false. I don't know, and it's hard to get a true sense of that, but we've adopted a jury system, and I believe in it strongly, and I believe that 12 ordinary people are the right people to try the facts in a case, but maybe we don't trust them enough.
The I don't know is a really powerful piece. You know, in every other aspect of the law, judges demand evidence before they make a ruling. In this area, we work on instinct, lawyers and judicial instinct, that juries can't be trusted. There's very little evidence to support that proposition, and I agree with you. In the 21st century, we are all world experts at sifting fact from fake news.
I certainly have that view. And I had 2 trials some long time ago now, in which if ever there was to be a verdict based on prejudice, these would be the trials. The first was the Russell Street bombing trial, in which 4 people were charged with the bombing, and the jury carefully discriminated in its verdicts between the possible roles of each of them. And they didn't convict them all, they acquitted 2, 1 went down for other things, but the reality was that there was a clear discrimination, and this is going back into the 80s, and at a time of a tremendous amount of hostility towards the accused. The second trial was not that long after, and involved the killing of 2 young police people in Wall Street. The Crown case in Wall Street was that a group of criminals murdered these 2 young men in reprisal for the killing of one of their number, and as a result of an agreement earlier entered into that if one of them should die, 2 police would die. It was part of the Crown case to establish that these were violent criminals. So that's where it started. That was what it was all about. But the jury did not accept that the evidence adduced by the Crown in that case was sufficient to convict them. And that was a trial where there was massive potential prejudice for if the jury did not perform its role properly. I have immense confidence in the capacity of juries in this regard, certainly considerably more than I would have in the determinations of some of the judges that I have sat with over the years.
Could I make a point on that? Because I've got I feel really passionately about this, and with the exception of course, the very learned, former judge here, who's obviously always made absolutely perfect decisions, and everything went really well.
With the greatest respect,
yes, with the greatest respect. Yes, absolutely. But
keep going.
Yes, yeah. He's so great, really. No. Anyway, no. I covered a case, for Four Corners last year. We did a documentary called I Am That Girl about a young woman called Saxon Mullins, who is an extraordinary young woman who was anally raped. It was found by jury by a young man within 5 minutes of meeting him. And so they were at it. She was at a nightclub. It was her first night out. She was a virgin. Pretty much her first time drinking, a reasonable amount of alcohol. She met him on the dance floor. Within 5 minutes, he said, "Do you want to come to this VIP area?" He brought her out the back of the nightclub to a laneway, got her on her hands and knees in the gravel, and anally penetrated her. Now, as I say, the jury convicted him. He was from a very wealthy nightclub family, well-known family in Sydney, and they appealed, and it was appealed on a technicality about the judge's directions to the jury, successfully. In New South Wales, there is the option of judge-only trials in examples where it's been a case of great public notoriety, and that's what happened in this case. It was overturned on appeal. Now, no fact finder in this case, including the appeal courts along the way, the judge only trial, the judge in the judge-only trial, all the jury thought that Saxon consented to this sex. They all agreed that she did not consent. But the judge found that that the perpetrator didn't know that she didn't consent, that he had a reasonable belief that she had consented. Now, I don't know the woman in Australia, maybe she's in this room, who would choose as her first sexual experience anal sex in gravel on her hands and knees at the end of a dark alley. Maybe she's out there somewhere. But this judge thought that he was reasonable to believe that. And he did know that she was a virgin, because there are text messages from the following day where he talks about popping her cherries. And he talks about it in a disparaging way. So when our show went to air, it had an enormous response. Australia believed Saxon. So she didn't get the justice that she wanted in the end, but she is a winner nonetheless. But I think that that's an example where a judge, respectfully, to her honour, made the wrong decision, and where a jury made the common sense decision.
The whole point here is around ensuring that justice is done fairly and equitably, and that trials are protected, and that suppression orders are one mechanism for achieving that. But, I mean, we've talked about the virtues of jury trials. But, Matt, are there circumstances where a judge-only trial is a useful path in order to protect?
I think it should be at least an available option. So Victoria is the only jurisdiction in Australia where it is not possible for an indictable crime to be tried before a judge sitting alone. In every other jurisdiction, that is an option. Must have the consent of the accused. And in cases of particular notoriety, it's a tool in the armoury to deal with the problem of prejudicial publicity.
So that avoids the whole problem of suppression orders, because you don't need to suppress.
You don't need to suppress because
judges are exempt from
one takes
that
it
sort of
that the judge is able to separate fact from fiction in a way that the jury presumptively cannot. That's the
proposition that I do not accept.
Hear, hear. Profoundly so.
I should say, to its credit, the Victorian government, I think with the support of the state opposition, is looking at introducing judge-only trials for indictable crimes, and that should be commended and supported.
I disagree.
Frank, is there a circumstance where a judge-only trial is appropriate?
Yes, there might be some situations where, in relation to national security, you might need to keep information very, very closely confined. There might be some where you're dealing with witness protection, where people's lives would be endangered if information was available in certain areas, but they are few and far between. There is absolutely no justification, in my view, for having a judge-only trial because a particular individual is well known, or because there may be community attitudes expressed about that person. I have grave reservations about that. I just don't accept that there ought to be a separate standard that applies there. And it doesn't always, and it seems to work in an odd fashion. For example, a serial killer called Peter Dupas was tried when it was well known that he was a serial killer. There was no question of that not going before a jury. We have tried people in New South Wales for the killing of Anita Cobby in circumstances where there was massive publicity about that matter well before it came on. when the good Darren Hinch, or the bad Darren Hinch that you choose, made comments about Glennon on the basis that he shouldn't be allowed to contact with children because he was a pedophile. He eventually went to jail for persisting in that. When Glennon was subsequently tried, Glennon's people argued that he couldn't have a fair trial because of what Hinch had said, and the court said, and the High Court went to the High Court, the High Court said, well, it was all curable by jury direction of the judge anyway. And Hinch had yet been jailed for it. So it's not as if these things are consistently applied. And it's not as if this information is always withheld. We have jury trials all the time across our community and the communities in the country, where everybody may know what's happened in a given situation. There are no suppression orders made in those circumstances. But yet it seems that in some circumstances we are so apprehensive about the fairness of the trial that a potential unfairness of the trial by disclosure that there has been another trial, that orders of this kind are made. In many cases where there has been a mistrial, the jury, the witnesses in the second trial are cross-examined on the basis of the questioning in the first, or where there's been a conviction appeal in another trial. This stuff floats around. It's not as clean cut as it is suggested.
So, Matt, is that a problem, the inconsistency of the application?
Absolutely. Yeah. And I agree with what's been said. In the vast majority of cases, criminal trials ought to be determined before juries, and the problem of publicity ought to be dealt with by jury directions. No one would suggest otherwise. But there can be very rare cases where the choice is between a judge-alone trial or no trial at all. And if the choice is no trial at all, because for whatever reason the court forms the view that a fair trial cannot be conducted before a jury, to me the lesser evil in those circumstances is to at least have the accused face a trial before a judge alone.
I guess it's a slippery slope, though. That's the problem. Like, who makes that decision, and are they making it for the right reason?
The culture, I agree. I think there's a real case for redressing the cultural problems which have become embedded, particularly in this state.
And do you think that's post-gangland?
Yeah, look, my own view is that the culture took root for perfectly logical reasons during the Melbourne Gangland Wars, when there were an enormous number of criminal trials going on in this city involving accused persons who had allegedly played different roles in respect of the same crimes. And in those circumstances, there were real difficulties of juries in one trial being infected by knowledge about evidence given in another trial to the detriment of the accused. One can understand why suppression orders were made in those circumstances, but the Gangland War has been over for years, and yet the culture has not reverted to the pre-Gangland culture.
Also, I mean,
That's a terrible expression, isn't it? You know what I mean.
Any journalist in the room will tell you that the suppression orders that, you know, as I said, come flying into the inbox. I mean, I see my colleague Karen Percy here. You look at these things, we don't even know who these people are. They're just some random whose lawyer has said that there should be a suppression order and no one opposed it. And it's a really sort of inconsequential matter that no one would actually cover anyway, you know? And that happens a lot. Can I just also say on the Hinch matter, as a law graduate and therefore sort of, you know, still a bit Pollyanna about these things, I would never oppose, you know, I would never breach a suppression order. But we have to remember that Hinch did that in the climate of a percolating crisis in the Catholic Church of abuse, which was being covered up right, left and centre in an environment in which victims had no agency and in which trials were split, and in which perpetrators were being freed because juries weren't convicting them. And there was a culture, and the Royal Commission talked about this, of not believing complainants. And actually, when you look at the, at the research on this, that the number of false complaints are very, very low, and usually confined to family court matters where there's one parent, pitted against another, or the floridly mentally ill. So while I wouldn't do what Hinch did, I think his frustration at the time was understandable, and his empathy for the victims was laudable.
We'll take some questions soon, and I'm very mindful of time. Sorry.
Can I just
Yeah, sure.
go back briefly to the idea of a judge-only trial? And with the greatest respect, Your Honour, I would suggest that a logic that says that the jury system is the system that we've chosen and juries are the best people to try facts, unless it's really important. And so I think if we do trust them to do that, just because it's volatile or just because it's sensitive or just because it's really important, we shouldn't replace them with what seems to be the superior model, which is having someone who's been to law school and been a barrister and become a judge and is able to do that job better. I'd still rather have 12 people make that decision, 12 ordinary people who can look at the facts as presented to them and make that decision.
Look, that's obviously totally misplaced. Everyone should know and appreciate that one judge is clearly smarter, more experienced, has more human empathy.
This one, of course.
And understanding than 12 ordinary mortals. I just don't even know how you can dispute that.
I remember when I was at law school, I have to say, there were a lot of people wandering around that place who thought that their shit didn't stink. And there are a lot of lawyers hanging around courts who think that their shit doesn't stink. And they treat journalists often with disdain and, again, with this paternalism. Like, oh, goodness, you wouldn't know about these matters, And it's just really, I think juries should be supported, and I think juries are sensible.
I think there's a whole other discussion on the relationship between the media and the law, but...
There's also a lot of really good ones who are sources, so I like them.
But before we take questions, I really want to go back to the tech question, because I think this has had, a very significant impact on the way in which we, understand or accept the success or otherwise of suppression orders. And, the Pell case was one in point, but there was also the Grace Milligan case out of New Zealand, where an algorithm, I don't know if you're all aware of this, but an algorithm generated in the US on, I think it was Google, threw up Grace Milligan's murderer in a New Zealand list of trending issues. So the algorithm actually broke the suppression order. So to your point earlier, Louise, how do you, bring these people to book or bring an algorithm to book? So we have all sorts of technological issues, including all sorts of definitional problems, Matt, around who's a publisher and whether or not that, any blogger or vlogger is liable to being hauled before the court?
Yeah, the short answer is yes, they are. But to me, the significant thing is if you go back to the pre-internet age, which most of us in this room have some passing familiarity with, the news was a curated view of the world. There was a daily newspaper, there was the 7 o'clock ABC News. News today is iterative. It evolves from minute to minute, and it's accessible ubiquitously, instantaneously and globally. So the effect of a suppression order, which for example stops the Age or the Herald Sun or the ABC from publishing or broadcasting a story, actually has the effect of elevating in a list of search results less reputable sources of news.
Absolutely.
Is that what we want?
And from people who don't have in-house lawyers going through the copy to make sure that it's sound, who don't have, editors, who don't have fact checkers, all of the things that I know we certainly at Four Corners have. Instead, it's what I reckon journalism, which is dangerous. And the court made it quite clear, I know, in the Pell case that for whatever reason, or the OPP, for whatever reason, they weren't going after those people. They were going after the journalists who had sort of hinted at things, who are the ones who were far more responsible. I don't understand how that's fair.
So I'm just thinking, Rod, in an instance where, a story literally goes viral and a victim like Grace is affected, in fact, she was sadly murdered in this instance, so her family were profoundly affected by this fact that this story broke through an algorithm. But we can well understand that a story might go viral, that it would publish information about not only the accused but about the victim, their family, their circumstances, all that stuff outside of any kind of manageable legal process. So the tech also has a real profound and potentially devastating impact on victims.
Oh, absolutely. And the inability to correct the record, the inability to engage with opinion, again, is just a re-traumatising aspect of the whole process. I think, through the trial process, just changing tack slightly, we need to be able to get to the correct outcome. And sometimes juries get that wrong, and sometimes there's a perception that it's because they knew something they shouldn't have known, and then it becomes appellable on that basis. But the reality is that for every jury trial, there's a risk of some knowledge, because it's ubiquitous, as you say. There's knowledge out there. So it's about level of risk. And I don't think we should set up a judicial system, a justice system, that says that, say in Mildura, where you have a limited pool of potential jurors and they all know each other. So you're going to have some sort of knowledge in that place. So if it becomes untenable to have a fair and just trial just because you live in the country, or just because there's a ubiquitous amount of algorithms out there that may infect your opinion, maybe we need to challenge that idea that the knowledge itself prejudices the trial.
And I'm sure that's the way to go. We cannot turn back the clock to the point that never existed anyway, that the jury will go in there with no information about anything, a completely blank slate and a blank mind, people who have no history, who have had no personal experiences of any kind that might associate with this case. Just these totally amorphous beings, apparently.
Who are these people?
But these were the jurors. These knew nothing about the case and would never be prejudiced by their own backgrounds and so forth.
12 people living under a rock.
But we had, and they would be guided by a judge who was all-knowing and wise and possessed of no prejudices of any kind, whatever. And its system worked, but we can't do that anymore. What we have to accept is that there is a much, much more sophisticated community that daily is forced more and more into discriminating between what is true and what is not. Even in whether you buy something online, you've got to search out whether the supplier is reliable. All of those kinds of things we live with every day. And I think we've just got to trust those people. We have to acknowledge that there will be information out there, and the system ought to be more concerned to direct them how to handle it, how to respond to it, and how to guide them through the process.
Could I also say, just on the question of the broader sort of controls around the courts. And so we have now in Victoria a system where victims are not only not named, but also their transcript is not available in sexual offence matters, historic, child abuse matters. They give their evidence at another location and all of that sort of thing. One of the problems that has happened with the Pell case, and in reference to the main victim in that case, he does want his privacy and that should be respected. But I wonder whether the transcript could not have been made available completely redacted for anything which would tend to identify him. Because unfortunately, these amateur Perry Masons out there on the internet have, in the vacuum that is left by his transcript, have thrown all these crazy conspiracy theories into that. They don't know the full details of the case because they're not there. And therefore, I think, there's a bit of a problem with that. I don't see why a transcript can't be there. And I'm not speaking for him, that he's a very private person, but it's just, I wonder whether there's a way that we can do that continues to protect someone who wants to be protected, but also doesn't give a platform for some of the nuttier conspiracy theorists and the rump of denialists who seek to protect the person who was at the top of the Catholic Church, and he's no longer, he's in jail.
So that brings us very neatly back to justice being seen to be done, and I suppose sunlight being the great antiseptic in terms of transparency around court processes. Matt, is that where we need to head?
It's so fundamental, and we say it glibly as if it's something only to have lip service paid to it, but this is critical. Our system, corruption flourishes in the shade, and the antiseptic of public scrutiny is the way in which we hold power to account. We think of it in terms of our politicians, we think of it in terms of national security laws, and we must think of it in terms of our judiciary. Australia is very well served by, overwhelmingly, a hugely dedicated, independent, incorruptible judiciary. We want to keep it that way. One way in which we do that is by ensuring that they perform their duties in sunlight.
We're going to take some questions, and there are a number for all of you, I'm very happy to say. One we can quickly knock off perhaps, Matt. Can you tell us where the media Pell contempt cases are up to?
No, I can't.
You can't? Okay, we'll move on. I thought that might not take very long.
I can. I'll tell you later.
And then another one, if at all, it's just bounced. How, if at all, has the public interest tipped away from granting suppression in sexual offence cases in the Me Too era, and where victims are finding their voices? Now, that's another interesting dimension to this. What do you...
The bigger issue there is a defamation issue rather than a contempt issue. So Australia's defamation laws, notoriously restrictive, I think have had a dampening or chilling effect upon victims coming forward and telling their stories for risk that they will find themselves a defendant in a costly, expensive, stressful defamation context.
And we've certainly seen evidence of that.
Yeah, well, there've been a couple of very prominent cases where we have to say the alleged victims, because they were not believed in either of the prominent cases, were subjected to very aggressive cross-examinations. I'm thinking about the Geoffrey Rush case, of course, and I'm thinking about the Christopher Gale West Indian cricketer case, in which, full disclosure, I acted for the defendant. But in those cases, you saw victims coming forward, alleged victims coming forward to give evidence to support the media, finding themselves aggressively cross-examined. Any victim out there who saw what those witnesses were subjected to would surely think very carefully before going and talking to Louise about their experiences.
Rod, this is one I think you should pick up. What role should the prosecutor play in conveying and representing the voice of victims on whether a suppression order should be made? Should that be part of their bailiwick?
Well, it's a good question, and I don't know whether it does fall with the prosecutor. I'd like to think that's probably where it falls, but each of the parties in a proceeding has some sort of agenda. And so there has to be quite an independent voice. So I'm not sure what it is. The public interest group that you suggested, Your Honour, may be the way of doing that if that were to be set up. But in the absence of anything else, I think the prosecution does that at the moment anyway, is what I understand, and sometimes do that very well. But it needs to be formalised in some way, and maybe just the culture move a little bit to bring victims more central to what's actually going on. Because at the moment, there are a lot of cases where they're certainly not central to what's going on, and decisions are made without ever hearing the opinion of a victim. So I don't know how to answer that question because I don't know exactly how it fits best, but at the moment, prosecution's probably the best bet.
We will take questions from the floor, so please put your hand up if you'd prefer to ask it directly. But another very interesting point that you alluded to a wee bit earlier, Louise, around split trials and the sort of effect that has, as described by Karen Percy, thank you for the question, as suppression by stealth, because basically it requires that there is no coverage until both trials are settled.
Absolutely. And I was talking to David Marr about this recently because he had been contacted by victims in the St Stanislaus sexual abuse Catholic cases in Bathurst in New South Wales, and there had been a series of split trials that had gone on. And because of those, the Royal Commission didn't have a case study because the matter was going on during its duration. And so they were sort of finally coming to an end well after the Royal Commission, and those victims had never had their moment, and those stories had never been made public. But unfortunately, because the Royal Commission was on for 5 years, and, you know, if you're like me, you know, every night you'd be driving home and Mark Colvin would come on and start talking about some awful abuse case. And unfortunately, the public appetite has waned in a way for hearing about some of those cases, unless it is someone very high profile like George Pell. And therefore it means that editors are unwilling to kind of commission these stories. So those people have been silenced by that process. And I think it's really wrong. And, you know, again, I just really feel through my experience with this that everything is weighted towards the well-resourced defendant. And the Catholic Church has played this game so well for so many years, and splitting trials has been one of its, you know, tactics that it's kept in its back pocket and used frequently.
This is a query that I was certainly keen to ask as well, and it's around the way in which the relationship between the media and the judiciary is now poisoned, if you like. And I think one of the justifications for the Open Courts review, as I understood it, Frank, was around the misreporting, as it was perceived by the judiciary at least, that the media were mishandling cases, and therefore there was a significant growth in suspicion and concern about access to information, and maybe that also fueled the fires of a number of suppression orders.
The actual process, I don't think started that way. It started because the media were complaining that there were far too many suppression orders made
absolutely.
In circumstances where they were not justified.
But the courts have certainly been critical.
And there is there is and has been for a very long time a toxic relationship between the media and the courts. The courts generally believe, and with some levels of justification at some occasions, that what they're doing is being sensationally presented and unfairly presented. And some of the orders, I ultimately concluded, were being made because the judge was concerned not only to protect the judge, but to protect the people in the court from unfair presentation in the media. So they saw themselves as protecting the legitimacy of the process and themselves at the same time. And the media, of course, were intensely dissatisfied because there were orders being made in circumstances where their justification seemed to be very doubtful indeed, and often were almost incomprehensible in terms of what they could or could not do in compliance with the order. I actually saw one order which said that there was to be no reporting of the matter forever. And, you know, it was just plain extraordinary. 22% of the orders that I examined, and I examined all orders made under the Open Courts Act for the 3.5 years that was involved in my study, 22% of them had no reason whatever provided as to why the order was being made.
So once again, that goes to transparency of the process.
It was really very poor, and I make a confession here as a former judge. I've never been enthused by the media, so when I took on this job, the first thing I did was to get the victims, the media and other groups of people, and I asked them to provide me with what they said actually had gone wrong. I didn't want cliches, I wanted information about what they said was wrong. And I asked the media to provide me with concrete examples to demonstrate the complaints that they were making. And they did. They provided me with lots of specific examples and materials. I secured access on a confidential basis to every suppression order that was made in the Victorian courts during the period. I had them all entered into a database which was then searchable in terms of the various complaints and so forth that had been made. And to my horror, I discovered that most of the complaints were valid.
That the media was excellent after all.
Well, they weren't excellent, but they clearly had powerful justification for the complaints that they were making.
They were right, weren't they, sir?
There was no
right.
doubt. No. I still find it hard to say that.
He's like the Fonz in Happy Days, you know, when he couldn't say sorry. He just couldn't get it out of his mouth. Media, excellent. Come on, admit it.
There were some of the ways in which cases were reported were disgraceful. Absolutely no shadow of a doubt about that. But their complaints about the processes were unfortunately valid. Well, I would have loved it to be otherwise.
And I mean, it may be the case that greater transparency and a central register and access to transcripts and justification for suppression orders where they are imposed would actually improve the standard of reporting, because it would give, media abhors a vacuum, and
Court reporting's really hard.
and it's
Yes.
very
It's hard enough for the lawyers to follow what's going on in the courtroom from day to day, let alone a journalist who is rushing from one courtroom to the next, running on a tight deadline with
and
no
finding
knowledge
full
of
platforms.
and not necessarily with access to the exhibits or the transcript. All of that makes that job very difficult.
And the lack of access to exhibits and transcript is one of the biggest issues that court reporters face. And I remember it when I was a court reporter, you were saying to the lawyers and to the court officers, you have to understand, I'm trying to be accurate. I want to report in the public interest what is really happening, not a truncated version of it. And then at the same time, in the same breath, the criticism would be that, you know, well, not of my journalism, of course, but of you know, of the media, that it was once over lightly. It's like you can't have it both ways, you know. Give us the access to everything so that we can do this properly and fairly and soberly.
Right, now that we've put the world to rights and that journalism is back at the, the apotheosis where it belongs, I think we probably need to draw a halt and give the library back its theaterette, because we are out of here, sadly. We're run out of time. But if I could ask you to thank, with great warmth and gusto, our panellists this evening. Matt Collins, Frank Vincent, Louise Milligan and Rod Ratcliffe, and to my team who have lined the walls this evening, who have pulled this together, very particularly to Georgia Angus and Alicia Ashcroft. This is Georgia's very last event for the Victoria Law Foundation, and I say that because this event was her idea. So thank you, Georgia, wherever you may be. And we wish her every success for all that comes next. As I mentioned earlier, you can hear this all over again on the website tomorrow, and please forward it to anyone who might be interested. And we look forward to having you back again next year. Safe home, and thanks again for coming.